Good afternoon. How's everybody doing? Great to be learning with you on a Friday, Erev Shabbos. Let's light up the darkness. Who's in the house on a Friday? Yom Shishi. Bella in Florida, Sharon in New Jersey, Renee in Indiana, Guy in Ohio, Lorraine in Texas, Melissa in Great Neck, Bella in Texas, Joe in the Inland Empire, Nancy in North Carolina, Aoife in Florida. Welcome, everybody. Single daf today, but it should hopefully set us up for a double. Well, we hate to do doubles at this time of year on Saturday night, but perhaps on Sunday. On Sunday, we are having a very special screening of Guns N' Moses at the Chabad Synagogue in Poway, California, where the shooting occurred in 2019 that inspired the movie. I think it's going to be very emotional. A lot of seats have been reserved. Looks like a sold-out show. We're donating the movie. The synagogue is actually giving away seats to the public for free, although accepting donations to the synagogue, of course, for people so inclined. But I think it's going to be a very emotional screening and hopefully an opportunity for healing. That's about a 2-hour drive from LA. It's at 12:30 in the afternoon, plus the Q&A. So we should have time to get back and do the class on Sunday on time. If anything happens, some weird traffic situation, maybe we'll be delayed by an hour or something, and we'll post that on the Facebook page if it's happening. But as of now, regular schedule, both Saturday night and Sunday. I checked earlier, we're running 6 pages behind the official Daf Yomi schedule, so we're 6 doubles away from being caught up. We're doing a pretty good job. I do want to mention, in all seriousness, Department of Homeland Security and FBI just issued an advisory that because of the rising threats to Jews in America, by violent extremists, we're at a situation of heightened alert. I forget what the exact verbiage of that. I shared it on the Instagram and Facebook story. What does it say? Didn't I? I thought I did. Hold on a second. I shared it. I know I did. Yeah. FBI DHS warned of elevated threat to Jews nationwide amid... Stop that. Amid rise... God, how do you do this? Amid rising anti-Semitic violence. Okay, so it's an elevated threat warning. It's something we have to take very seriously. So just be very vigilant. And if you see something... at a Jewish institution, at a synagogue, in a neighborhood, that's an anomaly, something that you think is unusual, something that is odd, something that looks off, don't ignore your instinct, report it, call the police, just keep an eye open, right? Keep an eye open around your surroundings. If you are a person who carries a firearm like I do, it's often very annoying to carry it. It's heavy. It's on your waist. You have to make sure that you've got your concealed permit on you. You have to balance it out with an additional magazine on the other side. It's not fun. It's something I wish we didn't need to do. But if you're a person who's licensed to carry, can carry, trained to carry, so carry. Right? We have to defend our communities. We can't be soft targets. Never again means that we share in the responsibility of protecting our community. Enough said. Okay. Our daf today is page 30 here in Tractate Shevuos, the 26th volume of the Talmud. We're picking this up near the end of chapter 2, and with God's help, we'll open chapter 3 today. So we got a little bit of the ways into 29b yesterday, and now we're doing the final Mishna of chapter 3, Mishna 7. We're starting Mishna 7 at the end of chapter 3 right now, as opposed to the halachas, the laws, of an oath of testimony, which is what we're going to be covering in chapter 4 in a few minutes. The final Mishnah of chapter 3 is sort of distinguishing oaths of utterance from oaths of testimony in terms of procedural matters. Right? So as opposed to the laws of an oath of testimony, when you're giving witness testimony or other kinds of testimony before a court, which will be discussed in the following chapter, the laws of an oath on an utterance apply to men and to women, to relatives and to non-relatives, right? As we shall see, women do not give witness testimony in a beis din, in a rabbinic court, and also the relatives of the litigants do not give a witness testimony. But on an oath of an utterance, a man or a woman can take an oath on an utterance, or can create an oath on an utterance, relatives and non-relatives, and those who are fit to testify, and those who are disqualified from testifying, whether the oath is taken in the presence of a court or not in the presence of a court, i.e. when one takes an oath on his own, at his own initiative. All of these apply to oaths of utterance as opposed to oaths of testimony. And for violating an oath intentionally, one is liable to receive lashes, and for doing so unwittingly, he is liable to bring the sliding scale sin offering. Liability for an oath taken in vain applies to men and to women, to relatives and to non-relatives, to those who are fit to bear witness and those who are disqualified, whether the oath is taken in the presence of a court or not in the presence of a court, and also when one takes an oath on his own. Right? If you're making an oath in vain, like saying that the moon is made out of green cheese, and you swear before God that that is so, that would be an oath in vain, and all these kinds of people in all these situations could create that liability for making an oath in vain. And with regard to both this, an oath on an utterance, and that, an oath taken in vain, even if he has administered the oath by others, he is liable. What does that mean? For example, if one said, if I did not eat today, or I did not wrap tefillin today, and another said to him, I administer an oath to you that your statement is true, right? The person is saying, he's stating, declaring that he did a thing or that he didn't do a thing, and somebody else says, "Oh yeah, do you swear before the Lord that what you just said is true?" And the person says, "Amen." Then he created an oath on an utterance, and if it's a false oath, he would be liable for swearing a false oath. That's Mishnah 7. Now the Gemara. Shmuel says, anyone who answers Amen after being administered an oath is like one who expresses an oath with his own mouth, as it is written in the context of the oath administered to a sota, the suspected adulteress, quote, and the woman shall say, Amen, Amen. Right? So in other words, the oath is stated by someone else, but the one who answers Amen, it's as if he stated or she stated the oath themselves. Rav Papa said in the name of Rava, an inference from the Mishnah and a Baraisa also support this when they are read precisely. As it is taught in the Mishnah on page 30a, which we'll get to momentarily, the oath of testimony is practiced with regard to men, but not with regard to women, with regard to non-relatives of the litigants, but not with regard to relatives, with regard to those fit to testify, but not with regard to those unfit to testify due to a transgression that they performed. And, like as we've seen elsewhere, dice players, right, professional gamblers are disqualified from giving testimony. So that's an example of somebody who'd be disqualified due to credibility issues. Women are disqualified, as we'll discuss, from giving testimony not because of credibility issues. And the oath of testimony is practiced only with regard to those fit to testify. And this oath applies both in the presence of a court and not in the presence of a court, i.e. when the witness takes the oath on his own that he has no knowledge of the matter. When somebody swears that they have nothing to offer as testimony, that's an oath of testimony. But if an oath is administered to the witnesses by others, they are not liable until they deny knowledge of the matter in court and take an oath to that effect. This is the statement of Rabbi Meir. Before stating the inference from the Mishnah, Rav Papa, that's the next Mishnah that we're going to be reading in chapter 4. Here it's being stated as a proof for Mishnah 7 of this chapter. As it is taught in a Baraisa, with regard to an oath of testimony, how is one liable to bring a sliding scale offering? A person said to witnesses, "Come and testify for me." And they replied, "On our oath, we do not know any testimony that concerns you, i.e., we have no knowledge of the matter, and therefore we can't come and be your witnesses in court." Or alternatively, they said, "We do not know any testimony that concerns you." And he said to them, "I administer an oath to you. Swear to me that you don't know anything." And they said to him, "Amen." So whether this oath was taken in the presence of a court or whether it was not in the presence of a court, whether it was taken by each witness by himself or whether it was administered by others, once they denied knowing testimony, which in fact they did know, then they are liable for swearing a false oath of testimony. Rav Papa asks, aren't the Mishnah and the Baraisa difficult as they contradict each other? According to the Mishnah, one is liable when the oath is administered by others only if it takes place in the presence of a court, while according to the Baraisa, one is liable even not in the presence of a court. Rather, isn't it correct to conclude from it that this statement in the Baraisa, where he is liable even not in the presence of a court, is referring to one who answered Amen to the administered oath? And that statement in the Mishnah is referring to one who did not answer Amen and is therefore liable only in the presence of a court. And the Gemara affirms, conclude from it that this is so. Ravina said in the name of Rava, the Mishnah that is here on page 29b also may be read precisely to support this point. As it is taught in the Mishnah, the laws of an oath on an utterance apply to men and to women, to relatives and to non-relatives, to those who are fit to testify and to those who are disqualified, whether the oath is taken in the presence of a court or not in the presence of a court, i.e. when one takes the oath on his own, meaning at his own initiative. He's not asked to swear by the Beis Din, by the rabbinic court. On his own, yes, but administered by the others, no. And it is taught in the last, if it's administered by others, no, not in the presence of a court, right? And it is taught in the last clause of the Mishnah with regard to this, an oath on an utterance, and that an oath taken in vain, even if it is administered by others, where they say, well, swear that such and such is so, and they say, Amen, that this could create liability for an oath in vain. Somebody says, swear that the moon is made out of green cheese. And he says, Amen, that is an oath in vain, and he's liable for it, even though he himself didn't swear that. Somebody else administered it to him, but he said, Amen. The other statements in the Mishnah are difficult as they contradict each other. Rather, isn't it correct to conclude from it that this latter clause of the Mishnah is referring to one who answered Amen to the administered oath? That former clause is referring to one who did not answer Amen and is therefore liable only in the presence of a court. And the Gemara asks, but since his statement can be derived from Tanaitic sources, meaning earlier rabbis of the Mishnaic period, what is Shmuel teaching us? And the Gemara answers, he is teaching us that the precise reading, he is teaching us the precise reading of the Mishnah. Since the law is not stated explicitly in the Mishnah, Shmuel saw fit to state it. And that concludes our discussion of Mishnah number 7, and with it, chapter 3. We move on to chapter 4 here in Tractate Shevuos. We're going to be focusing now on oaths of testimony, the oaths that people will take when they testify in a court or when they swear that they have no information to give the court. This is the oath of testimony. And so we find the source material for this very succinct verse, Leviticus 5:1. And if anyone shall sin, and he hears the voice of an oath, and he is a witness, or he saw, or he knew, if he did not utter it, he shall bear his iniquity. You can't stand idly by beside the blood of your brother. And that's normally referring to the requirement that if you can save a life, you save it. But also, you might be able to save a life by providing testimony on behalf of a defendant, and you can't what's the word I'm looking for? You can't refuse. You must give testimony when you know testimony in a matter. Okay, Mishna number 1 here in chapter 4. What is the word that I'm looking for? Not neglect, not refuse, but opt not to. There's a word, decline. You cannot decline to give testimony. There we go. Okay, Mishna 1. The oath of testimony is practiced with regard to men, but not with regard to women, with regard to non-relatives of the litigants, but not with regard to relatives, with regard to those fit to testify, but not with regard to those unfit to testify due to a transgression that they performed. And the oath of testimony is practiced only with regard to those fit to testify. Right? So, and we'll talk a little bit about this more, but women are disqualified from giving testimony in a rabbinic court as witnesses, right? And there are other people who are also disqualified from giving testimony. Minors don't give testimony. Certain kinds of disabled people don't give testimony. Certain kinds of people with credibility issues who have been convicted of certain crimes, they don't give testimony. So a person who's disqualified from giving testimony, if they and the one administering the oath don't realize for some reason that they're disqualified, and so they administer an oath, well, do you know something? And they say, no, I don't know anything. Do you swear an oath of testimony that you don't know anything? And they say, I swear, right? And then and it turns out that they do know something. Are they liable for swearing a false oath of testimony? No, because they were never fit to give testimony in the first place. The oath of testimony is practiced both in the presence of a court and not in the presence of a court, when the potential witness takes the oath on his own. But if the oath is administered by others, and those denying that they witnessed the incident in question neither take an oath nor answer amen to the administered oath, they are not liable until they deny any knowledge of the incident in question in court, right? Just denying that you know something does not mean you swore a false oath of testimony. You have to actually be administered the oath. This is the statement of Rabbi Meir. And the rabbis say whether one of the witnesses takes the oath on his own or whether the oath is administered by others, the witnesses are not liable until they deny any knowledge of the incident in question before the litigants in court. Right? So an oath of testimony saying that you don't know anything that's relevant to the matter, even if you swear to that outside of a court or even in court, but not in the presence of the litigants, doesn't trigger liability for swearing a false oath of testimony until all those conditions are met. You swear that you don't know what in fact you did, and you swear to that effect before the judges and the litigants in the court. And one is liable for the act of taking a false oath with intent and for an unwitting act of taking a false oath, i.e., he is unaware of the liability for taking a false oath, provided that he takes the oath with intent in terms of the testimony, i.e., he takes an oath that he has no knowledge of the matter, even though he knows that he did witness the incident. But witnesses are not liable for taking the oath if they were unwitting in terms of the testimony, i.e., they believe they have no knowledge of the matter, and then they realize that they do. That's not considered unwitting. Wait a minute. If they weren't right, if they didn't think that they knew anything, and then it turns out that they did, that's going to be circumstances beyond their control. Whereas, let me just read this again. One is liable for the act of taking a false oath with intent, and for an unwitting act of taking a false oath. Okay, so if it's with intent, you know that you saw it, you deny that you saw it because you don't want to testify. That's intentional false oath of testimony. And then there is liability for an unwitting act. Now the question is, what is the unwitting act? Let's read it carefully. Now in this case, it's defined as he is unaware of the liability for taking a false oath, provided that he takes the oath with intent in terms of the testimony. Right? I.e., he takes an oath that he has no knowledge of the matter, even though he knows that he witnessed the incident, but he doesn't know that this is that it's prohibited to do that, right? I mean, he should know that he's lying. But if he doesn't know what the consequences are for denying that you saw it, then we're going to call that unwitting false oath, right? So it's not going to be intentional and receive lashes because he didn't know it was such a, let's say he didn't know it was such an important thing that he can say, I have no knowledge, when in fact he does. Since he didn't know what the consequences of that would be, we're going to call that unwitting violation of the oath of testimony. But witnesses are not liable for taking the oath if they were unwitting in terms of the testimony. So if they didn't think they knew anything when they swore the oath, and then they go, wait a minute, I was there. I did see something that is relevant. When they swore the oath, they weren't lying. So we're going to call that circumstances beyond their control, even beyond unwitting, and therefore they don't become liable to bring the sin offering. And what are they liable for by taking a false oath with intent? They are liable to bring a sliding scale offering, which seems odd. Not lashes, but the sliding scale offering when they do it intentionally. Let's read on. The Gemara. The Mishna teaches that the oath of testimony is not practiced with regard to women because they are unfit to testify. Now, is this some kind of a slander against women? No. As we shall see, the reason that women are disqualified from giving witness testimony in a rabbinic court is not because there's something wrong with women. It's simply the language of the Torah. This would actually qualify as a chok, right? One of the chukim. In other words, a law that is beyond rationality. We don't know why this is so. It's just that the Torah says so. Now, people have speculated over the centuries that perhaps this is because, especially in the ancient world, women were very modest. They didn't want to go and appear in public places. Although there are reasons, but we know that this is not an issue of credibility because there are areas of the law where women do give testimony and they are believed. They are credible to give testimony in certain kinds of cases. So where it comes to acting as witnesses, it is not a credibility issue. It's just the written language of the Torah. Another explanation is, women are rightfully considered to be more emotional. In other words, they have a mandate from God to be more emotional, and that is a positive quality because it also makes women to be more compassionate. Which is perhaps the primary quality in God that we seek to emulate, right? To be led with chesed, right? To be able to express loving kindness. We balance that out with gevura, restraint. But we'll say that men sort of tip the scale a little bit to gevura over chesed, and women tip the scale a little bit to chesed over gevura. And maybe that's why, because women are more compassionate, they're prevented from giving witness testimony. But that is mere speculation. The actual reason, as the sages will now derive, is because the Torah says so, and we don't know why. So let's keep reading. The Mishna teaches that the oath of testimony is not practiced with regard to women because they are not fit to testify. And the Gemara asks, from where is this matter that women do not testify derived? And the Gemara asks, it is as the sages taught in a baraisa when the verse states, if an unrighteous witness rises up against any man, then the two men shall stand. This is Deuteronomy 19, verses 16 and 17. So it is with regard to witnesses that the verse is speaking. Apparently, men, not women, may testify because the language in the Torah is two men shall stand. So the Baraisa continues, do you say that it is with regard to witnesses? Or perhaps it is only with regard to litigants that the verse is speaking. When it states between whom the controversy is in Deuteronomy 19:17, the litigants are already stated in the verse. How do I realize the meaning of the phrase, then the two men shall stand? Apparently, it is not referring to the litigants. It is referring to the other pair that is in court. And who are they? The witnesses. So when it refers to the two witnesses as the two men, not the two people, not the two humans, but the two men, It must mean that the witnesses are men, and therefore women are not not disqualified from testifying as witnesses. And if it is your wish to say that this is not a proof, another proof may be cited. It is stated here, the two men, and it is stated there, on the basis of two witnesses shall a matter be established. Just as there, with regard to witnesses, the verse speaks, so too here, with regard to witnesses, the verse speaks. And the Gemara asks, what is the meaning of the statement of the Baraisa? And if it is your wish to say, why is the initial proof inadequate that you would question it? And the Gemara answers, and if you would say that from the fact that the verse did not write, then the two men and those between whom the controversy is shall stand, which would indicate that the verse changes its focus from the witnesses to the litigants. Perhaps through the entire verse, it is with regard to litigants that it is speaking. Therefore, the Tana of that Mishna cites, or of that Baraisa, cites an additional proof. It is stated here, the two men, and it is stated there on the basis of two witnesses. Just as there is with regard to witnesses that the verse speaks, so too here, with regard to witnesses, it is that the verse speaks. It is taught in a different Baraisa. When the verse states, then the two men shall stand, it is with regard to witnesses that the verse is speaking. And do you say that it is with regard to witnesses? Or perhaps it is only with regard to litigants that the verse is speaking? So the Tana asked, did you say that? If the reference is to litigants, why does the verse mention two? Do two people come to court for judgment, but three people do not come to court for judgment? And if it is your wish to say that this is not a proof, another proof may be cited. It is stated here, the two men, and it is stated there on the basis of two witnesses. Just as there it is with regard to witnesses that the verse speaks, so too here it is with regard to witnesses that the verse is speaking. And the Gemara asks, what is the meaning of, and if it is your wish to say, why is the initial proof inadequate? And the Gemara answers, and if you would say that even though there are cases where there are more than two litigants, it is with regard to the plaintiff and a defendant that the verse is speaking. The basic concept of court is that there's a plaintiff and a defendant, and that's why we would say two litigants. So if we're just talking about two men, why can't that be referring to the litigants rather than the witnesses? Therefore, the Tana cites an additional proof. It is stated here, two men, and it is stated there on the basis of two witnesses. And just as there it is with regard to witnesses that the verse speaks, so too here it is with regard to witnesses that the verse speaks. And it is taught in another Baraisa. Now we're on the third Baraisa that is going to basically make the same proof, but slightly different logic and wording. When the verse states, then the two men shall stand, it is with regard to witnesses that the verse is speaking. But do you say that it is with regard to witnesses? Perhaps it is only with regard to litigants that the verse is speaking. So the Tana of that Baraisa, the third Baraisa, asks, did you say that? If the reference is to litigants, why does the verse mention men? Do men come to court for judgment, but women do not come to court for judgment? Right? Women certainly can come to the court for judgment. They can be either a plaintiff or a defendant in a case, right? It is only for witnessing, acting as one of the pair of witnesses that women cannot do according to Torah law. And if it is your wish to say that this is not a proof, another proof may be cited. There it says these two men, and there it says those two witnesses, and these two are referring to the same issue, which is witnesses. And the Gemara asks, what is the meaning of it? If it is your wish to say, why is the initial proof inadequate in this third Baraisa? And the Gemara answers that it means, and if you would say that with regard to a woman, it is not typical conduct for her to appear in court due to the verse that is stated with regard to women in Psalm 45, verse 14, all the glory of the king's daughter is within, right? Speaking about modesty. And that is why the verse addressed a situation that is prevalent, i.e., a case where the litigants are men. And there is no proof that women are unfit for testimony. Okay, maybe typically men are litigants and typically men are witnesses, but that doesn't mean that women are disqualified. That's the challenge. So if that's not enough for you, then it is stated here, these two men, and it is stated there, by two witnesses shall a matter be established. And just as the first phrase is regarding witnesses, so is the second. Now, the Gemara cites another interpretation of the verse. The sages taught, then the two men shall stand. Now, we were using that phrase to prove that being a witness in a rabbinic court does not apply to women. It only applies to men. But now we're going to use the same phrase for a different matter. Then the two men shall stand. This indicates that there is a mitzvah, a commandment, for the litigants to stand during the court proceedings. And the law actually ends up being that either they're both standing, or the court may say, maybe they've been standing for a very long time, and say, you may sit down. But then they both have to be sitting. But the normal way is that both litigants are standing up. So you ever see like People's Court on TV? Both the plaintiff and the defendant are standing. That's the way it is in a rabbinic court. They both have to be standing. If it's going to be permissible for them to sit down, then they both have to be sitting because you physically want them, the plaintiff and defendant, to be treated equally. Rabbi Yehuda said, I heard that if the judges wish to seat both of the litigants, they may seat them. What then is prohibited for the judges? Well, they must ensure that there will not be a situation where one litigant is standing and one is sitting, or a situation where one litigant says everything that he needs to say to present his case, and the other litigant, about him, the judge says, curtail your statement. In other words, you don't allow one of the litigants to talk as long as he wants, and the other one, you cut him off. Right? They both have to be given equal airtime in court. The sages taught, the verse states, but in righteousness shall you judge your colleague, from which it is derived, the court must ensure that there will not be a situation where one litigant is sitting and one litigant is standing, or a situation where one litigant says everything that he needs to say and the other one is curtailed. Alternatively, it is derived from the verse, but in righteousness shall you judge your colleague, that you should judge another favorably and seek to find justification for his actions, even if, when interpreted differently, his actions could be judged unfavorably. Right? You have to give them an opportunity to state their best case and to be respected by the court equally, plaintiff and defendant. Rav Yosef teaches that from the verse, but in righteousness shall you judge your colleague, amitecha, it is derived with regard to one who is with you, im she'itecha, in observance of Torah and in fulfillment of mitzvahs, try to judge him favorably in the manner that the Gemara will now explain. So what's this saying? The Gemara explains with an incident. Rav Ula, the son of Rav Ilai, had a trial pending before Rav Nachman. Okay, so Rav Ula, who is a sage, is now going to appear as a litigant in the court of Rav Nachman, who is another sage. Rav Yosef sent a message to the judge, to Rav Nachman, saying, Ula, our friend, is a colleague in Torah and mitzvahs, right? He is a fellow Torah scholar. He's a fellow sage like us. With regard to whom the verse states that you should judge him favorably. Rav Nachman said, for what purpose did he send this message to me? Does he expect me to grant him preferential treatment? Every judgment must be undertaken with righteousness. I'm not going to give preferential treatment to a Torah scholar if he's having a litigation with an haaretz, with an ignoramus, right? We're not going to say that just because, he's probably a righteous person, since he is a well-known and respected sage, and this other person is not a Torah scholar, is not a sage, just an average Joe, that doesn't mean that the plaintiff is automatically right and the defendant is automatically wrong. We're not going to make such an assumption. So Rav Nachman then, right, every judgment must be undertaken with righteousness. Rav Nachman then said, Rav Yosef sent me the message to ensure I would open with Rav Ula's dispute in the event that other cases come before me for judgment in deference to the Torah because he is a Torah scholar. It's not that he's going to be treated more deferentially than the other litigant in his own case, but if he's got, a slate of cases that he has to hear that morning, he will take the case of the Torah scholar first while he's fresh, and then the Torah scholar can get back to studying and teaching Torah, rather than just sitting around in court where he's not able to do that, right? So that kind of preferential treatment he would get just to have the case heard sooner. but not to have a higher hand in his own case than the other litigant. Now we're on page 30b. Alternatively, Rav Yosef informed me that Rav Ula, right, this is now Rav Nachman talking. Alternatively, Rav Yosef informed me that Rav Ula is a Torah scholar with regard to circumstances where the ruling is not clear-cut and the decision is rendered based on the discretion of the judges. That is, when the court is unable to rule solely based on the testimony presented in court, and the judges arrive at their ruling based on their sense of the matter. Rav Yosef informed Rav Nachman that if the case is decided based on this kind of liminal matter where judicial discretion has to be used, then Rav Ula is worthy of having the decision ruled in his favor. In other words, Rav Yosef is saying to Rav Nachman, listen, Rav, it's a character witness, right? Rav Ula is a righteous person of tremendous integrity, and if all other matters being the same, if the integrity of one of the litigants is going to have some bearing on the outcome of the case, then you can rest assured that Rav Ula is a person of great integrity. Next issue. Ula says, the dispute between the rabbis and Rabbi Yehuda with regard to the obligation to stand in court, right, that both litigants are standing or both are sitting, there is a dispute between the rabbis and Rabbi Yehuda with regard to this issue, but only with regard to the litigants. But with regard to witnesses, everyone agrees that they testify while standing. As it is written, then the two men shall stand. And Rav Huna says the dispute whether the litigants are required to stand is only at the time of the deliberation. But at the time of the verdict, everyone agrees that the judges issue the verdict while sitting and the litigants receive the verdict while standing. The judges are sitting, the litigants are standing before them when they receive the verdict of the court. As it is written, quote, and Moses sat to judge the people, and the people stood. Exodus 18:13. So that is the paradigm for all rabbinic courts. At the time of the verdict, judges are sitting, litigants are standing. The Gemara presents an alternative version of the statement of Rav Huna. The dispute as to whether the litigants are required to stand is only at the time of deliberation, but at the time of the verdict, everyone agrees that the judges issue the verdict while sitting, and the litigants receive the verdict while standing. As concerning the witnesses, the status of the stage of their testimony is like that of the stage of the verdict, and it is written concerning them, then the two men shall stand. When the witnesses give their testimony, they must be standing, and apparently, since they have to come as at least a pair of witnesses, both of them are standing, even while one of them is talking. The Gemara relates an incident. The wife of Rav Huna had a trial pending before Rav Nachman. Rav Nachman said, what should we do? If I will arise before her in deference to her status as the wife of a Torah scholar, the claims of the other litigant will be suppressed, as it will be mistaken as a display of preference for the wife of Rav Huna, since not everyone is aware that one is required to show deference to the wife of a Torah scholar. Right? Very interesting. Just as we have prominent rabbis and teachers, when they walk in the room, we all stand, right? The students or the people who are going to hear the lecture, we all stand when this prominent rabbi walks into the room. Well, if the wife of that prominent rabbi walks into the room, we all stand in the same way. But not everybody knows that. So what's the judge to do? He says, if I will not rise before her, well, that would run contrary to the principle that in terms of deference, the status of the wife of a chaver is like that of a chaver, right? A chaver, a friend, a companion, but in this context, it means a fellow Torah scholar. And we, Torah scholars, chaverim in this situation, are meticulous in their observance of the commandments. So what is Rav Nachman to do? He needs to stand before the wife of a fellow Torah scholar when she enters the room. But since not everyone knows that the reason he's standing before her is because she's the wife of a scholar, then some people will think that the judge is favoring one litigant over another. So what should he do? Rav Nachman said to his attendant, "Go outside and cause a duck to fly and cast it into me. And in that way, I will be forced to arise in a manner that will fulfill the obligation to rise without intimidating the other litigant," right? Create a situation where I'll have to stand and I'll know that I'm standing in deference to her, but to the rest of the court, it'll seem like some outside matter made me stand and that it won't look like I'm favoring one of the litigants. The Gemara asks, but doesn't the master, in this case Rav Huna, say, the dispute between Rabbi Yehuda and the rabbis, whether the litigants are required to stand, is only at the time of the deliberation. But at the time of the verdict, everyone agrees that the judges issue the verdict while sitting, the litigants receive the verdict while standing. How then can Rav Nachman rise? And the Gemara responds, one may fulfill both requirements in a case where he sits like one who unties his shoe, neither completely standing nor completely sitting, and he says his verdict, so-and-so you are innocent and so-and-so you are guilty. New subject. Rabba bar Rav Huna says, in this situation where a Torah scholar, letzurva merabanan, and an am haaretz, right? A Torah scholar and an am haaretz, right? Meaning nation of the land, but it means an ignorant person. A Jew, meaning a Jew who is not well versed in Torah law. In a situation where a Torah scholar and an am haaretz have a court case with one another. So we seat the Torah scholar, and to the am haaretz we also say sit. Right? So both litigants are going to be on the same level. And if he chooses to stand due to deference, we have no problem with it. Right? If the litigant, who's an am haaretz, chooses to stand because he's acknowledging that the other litigant is a Torah scholar, he can do so. But the court will treat them equally. The Gemara relates Rav bar Sherevia had a trial pending before Rav Papa. Rav Papa seated him and also seated his litigant counterpart, who was an am haaretz. An agent of the court came and kicked and stood the am haaretz on his feet to show deference to the Torah scholars there. And Rav Papa did not say to him, sit. And the Gemara asks, how did Rav Papa act in that manner by not instructing the am haaretz to sit again? But aren't the claims of the am haaretz suppressed by Rav Papa's perceived preferential treatment of the other litigant, who was a Torah scholar, Rav bar Sherevia? And the Gemara responds, Rav Papa said to himself that the litigant will not perceive bias. As he says, the judge seated me. It is the agent of the court who is displeased with me and compelled me to stand. And Rabba bar Rav Huna says, in this situation where a Torah scholar and an am haaretz have a court case with one another, let the Torah scholar not come to court early and sit with the judge in order to learn from him, due to the fact that by doing so, he appears as one who is consulting the judge to arrange his legal claims, and that is prohibited. And we said this only in a case where there is not a fixed time for the Torah scholar to study with the judge at that hour. But if there is a fixed time for him to study with the judge at that hour, we have no problem with it. As the other litigant will say, he's occupied with his fixed study time. And the fact that he sat before the judge is unrelated to the case. New subject. And Rabba bar Rav Huna says, in the case of a certain Torah scholar who knows testimony relevant to a certain individual, but it is a demeaning matter for him to go to court, consisting of a judge who is less prominent than he is, in order to testify before him, let him not go and testify. Now that's surprising. Right? So we said that you cannot withhold testimony if you know testimony that is relevant to a judicial matter. But now we're saying, well, but if the witness is a Torah scholar, and it's going to be demeaning for him to go appear in the court of a lower Torah scholar who's acting as the judge, then this more prominent Torah scholar can decline to give testimony? Really? Let's keep reading. Rav Shesha, the son of Rav Idi, said, We learn that law in a Mishna, Tractate Bava Metzia 29b as well. If one found a sack or a basket, and it is not his typical manner to take it, he shall not take it in order to return it to its owner. Evidently, a Torah scholar may refrain from performing the mitzvah to return a lost item if it is not in keeping with his stature. And the Gemara notes, this matter applies only with regard to cases involving monetary matters. But in cases involving ritual matters, the dignity of the Torah scholar is not in consideration. As it is written, there is neither wisdom nor understanding nor counsel against the Lord, from which it is derived. That's Proverbs 21. Wherever there is a desecration of the name of the Lord, one does not show deference, not even to a Torah scholar. Rather, the Torah scholar forgoes the honor that is due to him in order to avoid violation of any prohibition that would desecrate the name of God. The Gemara relates, Rav Yemar, new testimony relevant to the case of Mar Zutra. He came before a Maimar, who seated all the witnesses in deference to Rav Yemar. And Rav Ashi said to a Maimar, but doesn't Ula say that the dispute between the rabbis and Rabbi Yehuda with regard to the obligation to stand in court is only with regard to the litigants, but with regard to the witnesses, everyone agrees that they testify while standing. Maimar said to him, this, i.e. witnesses standing during testimony, this is a positive mitzvah, a thou shalt. And that, i.e. treating Torah scholars with deference and allowing Rav Yemar to sit, is a positive mitzvah, another positive mitzvah. And the positive mitzvah of deference to the Torah takes precedent, right? Because showing deference to a Torah scholar is like showing deference to the Torah itself. Maimar seated Rav Yemar in deference to the Torah. In order to prevent a miscarriage of justice, he seated all the witnesses. Now the Gemara provides a mnemonic for the upcoming discussion. Advocacy, ignoramus, robbery, fraud. The sages taught, from where is it derived that a judge should not engage in advocacy for his own statements and devise various pretexts to justify his erroneous rulings? It is derived, as the verse states, distance yourself from a false matter. And from where is it derived with regard to a judge that a student who is an ignoramus should not sit before him to discuss the proceedings? It is derived from as the verse states, distance yourself from a false matter. When an ignorant student engages in the proceedings, he is apt to cause the judge to err in judgment, right? In all these cases, who is a judge? He's an expert in Torah law, right? So what is going to be the basis for which one litigant prevails over another? Torah law. So you want, paskening rabbayim, right? Like great rabbis who understand all the ins and outs of the relevant areas of the law to this case and to deliberate in a righteous matter according to Torah law. But the rabbis themselves have to know and have to be humble enough to say, I'm an expert, but what if I'm making a mistake? So they state their case, right? And then they listen to the other rabbis state their case. And they don't get all impassioned about their own position because maybe they're wrong, right? So they just state the case according to Torah law as well as they understand it. But who we don't admit into the deliberations of the judges is a lesser Torah scholar who is not expert enough to engage with them because he might cause them to go astray. From where is it derived that a judge who knows that another judge is a robber and is disqualified from serving as a judge, and likewise a witness who knows that another witness is a robber and is disqualified from serving as a witness, from where is it derived that he should not join him in judgment or testimony, right? If you know that another judge on this panel is a robber and therefore disqualified from acting as a judge, well, you can't judge alongside him. You're going to have to either recuse yourself if you're not, sure enough to bring the charge publicly, or you bring the charge publicly, but what you don't do is just go along with it. Neither with a fellow judge who is a robber, nor with a fellow witness who is a robber. From where do we derive that? Because the verse states, distance yourself from a false matter. From where is it derived that in a case where a judge who knows that the witnesses testifying before him are lying, even though he is unable to prove it through their cross-examination. And with regard to the verdict, the result will be that it is fraudulent, that he should not say, since the witnesses are testifying and I cannot prove their deceit, I will decide the case based on their testimony and let the chain, the collar of culpability for the miscarriage of justice be placed around the neck of the false witnesses. How do we know that he shouldn't do this? It is derived, as the verse states, distance yourself from a false matter. Right? The judge has a strong instinct these witnesses are lying. He can't prove it. So what does he do? Does he say, well, my hands are tied? Maybe my instinct is wrong. So I'm going to have to just decide the case based on the testimony they've given me. And if indeed it is false and the litigant suffers because of it, okay, well, that's going to be on the head of the witnesses. They'll be called to account for that someday, perhaps before the heavenly court. How do we know he doesn't do that? Because he distanced himself from a false matter. So if he really has a strong instinct that these witnesses are lying, he's going to have to set about trying to prove that they are lying so that the litigant doesn't suffer as a result of these lying witnesses. Now the Gemara provides a mnemonic for additional laws derived from the verse, distance yourself from a false matter, 3 relating to a student and 3 relating to creditors, and the 3 relating to a judge. Rags, hears, and explain. Mnemonic device. We're on page 31a, getting a little bit of a head start on tomorrow's page. From where is it derived with regard to a student who is sitting before his teacher and sees a claim that provides advantage for a poor person and disadvantage for a wealthy person, that he shall not remain silent? It is derived, as the verse states, distance yourself from a false matter. From where is it derived with regard to a student who sees his teacher who is erring in judgment, that he shall not say, I will wait for my teacher until he concludes the trial, and then I will contradict him and construct a ruling of my own so that the verdict will be attributed to my name? It is derived, as the verse states, distance yourself from a false matter. And from where is it derived with regard to a student whose teacher said to him, you know concerning me that even if one were to give me 100 times 100 dinars, right, 10,000 dinars, I would not fabricate a claim. Now I have 100 dinars in the possession of so-and-so to whom I lent money, but I have only one witness of the 2 required to testify about the loan and enable me to collect the payment. So from where is it derived that the student shall not join with the other witness and testify? It is derived, as the verse states, distance yourself from a false matter. Right? You can't have somebody who's so righteous, he's like, I'm telling the truth. I would never lie about this. So because you know me to be of sterling character, and sadly I have only one witness to bring with me in order to get this person who owes me money to pay me back. So you, my student who knows what a righteous Torah scholar I am, you act as the second witness and testify that so-and-so owes me money. But the student doesn't know about the loan. He could only act as a character witness, and that's not an eyewitness. If the Torah scholar who's saying I'm so righteous and I'm so righteous, why is he asking the student to lie? That in itself would be a contradiction. But at any rate, if he did say something like that, the student should not join in as a witness when he in fact is not a witness. And therefore, and what is the reason for that? Distance yourself from a false matter. And the Gemara asks, is it from the verse, distance yourself from a false matter, that this particular matter is derived about the righteous rabbi who asked his student to lie, if that ever happened? But isn't he certainly lying in that case? And this is already stated, as the merciful one states, you shall not bear false witness against your neighbor. In Exodus 20, verse 13. Rather, the reference, in other words, we don't need distance yourself from a false matter. If the rabbi is asking a student to lie, that's already bearing false witness. So what is the issue that we would derive from distance yourself from a false matter? Right? Not only don't lie, but don't even approach lying. Rather, the reference is to a case where the teacher said to him, it is certain that I have one witness, and you come and stand there beside him and do not say anything, as in that manner you do not express a lie from your mouth. Your silent presence will create the impression that I have 2 witnesses, and lead the debtor to admit his debt. Even so, it is prohibited to do this due to that which is stated, distance yourself from a false matter. There are 3 laws with regard to a creditor. From where is it derived with regard to one who is seeking repayment from another of a debt of 100 dinars, and there are no witnesses to that effect, that he shall not say, I will claim that he owes me 200 dinars, so that he will admit that he owes me 100 dinars, and he will become liable to take an oath to me, the oath of one who admits to part of a claim, and on that basis I will extend the oath and compel him to take an oath with regard to a debt that he owes me from another place. It is derived, as the verse states, distance yourself from a false matter. Don't use your knowledge of the laws of testimony that you can make somebody swear a partial oath, right? Like, this guy owes me 100 dinars. I know he owes me 100 dinars. He knows that he owes me 100 dinars. If I say to him, you owe me 200 dinars, right? Then he'll say, no, I only owe you 100. And I'll say, okay, well, swear. That would be a partial, that swearing to a partial acknowledgement of the charge that was leveled against him. Once he's swearing such an oath, then let's say I have an unrelated loan. I also lent him money about something else at another time, but now that he's already swearing an oath, I could get him to swear about that as well. That would be taking advantage of your knowledge of the laws in a way that is unscrupulous, and therefore don't do it. It's not permitted due to the verse, distance yourself from a false matter. From where is it derived with regard to one who is seeking repayment from another of a debt of 100 dinars, and he claims that the debtor owes him 200 dinars, that the debtor shall not say, I will completely deny his claim in court, and I will admit to him outside court, so that I will not become liable to take an oath to him, and he will not extend the oath and compel me to take an oath with regard to some other debt that I might have. How do we know that it's not permitted for the debtor to do that? Distance yourself from a false matter. And from where is it derived with regard to 3 who are seeking repayment from one individual for a total of 100 dinars, that one of the 3 should not assume the role of the sole litigant and claim all 100 dinars, and the other 2 will assume the role of witnesses, so that they will exact payment of 100 dinars from the debtor and divide it among them. Right? Now here, that is the actual situation. He owes 33 1/3 dinars to each of these 3 people. But there are no witnesses to that. So they could say, okay, let's just say he owes 100 to one of us and the other 2 will act as the witnesses. And in that way, we'll get the same amount, 100 dinars, which will divide among the 3 of us. But you're getting there by way of a lie, right? That one is the lender and the other 2 are witnesses. Distance yourself from a false matter. There are 3 laws with regard to a judge. From where is it derived with regard to 2 individuals who came to judgment, one dressed in rags and one dressed in a garment worth 100 times 100 dinars, that the judges say to the wealthy person, dress like the poor person, or we say to the poor person, dress in a garment like yours. In other words, we don't allow them to appear in court looking totally different. From where do we derive this? Distance yourself from a false matter. And the Gemara relates, we do tell them to dress like in some kind of, either you're both going to look rich or you're both going to look poor, but we're not going to have one look rich and one look poor in court, right? So Rav, from where do we derive it? I mean, so distance yourself from a false matter. And the Gemara relates an incident when individuals would come before Rav Bar Rav Huna for judgment. He would say to them, remove your fine shoes and descend for judgment, so you will not appear more distinguished than the other litigant. I'm almost done. Questions or comments, please get them in now. From where is it derived that a judge should not hear the statement of one litigant before the other litigant arrives in court? It is derived as the verse states, distance yourself from a false matter. Both litigants have to be in court when each of them is testifying. From where is it derived that a litigant shall not explain the rationale behind his statements to the judge before the other litigant arrives in court? It is derived, as the verse states, distance yourself from a false matter. And Rav Kahana teaches this law, that this law is derived from the verse which is written, you shall not accept a false report, Exodus 23:1, which he interprets as though it is written, you shall not cause others to accept a false report. And finally, the verse states, and did that which is not good among his people, Ezekiel 18:18. Rav says this is referring to one who comes to court with authorization to present claims on behalf of another person. And Shmuel says this is referring to one who purchases a field concerning which there are those who contest ownership of it, as in that way he involves himself in the disputes of others, something we frown upon. That's where we'll pick it up, God willing, tomorrow night when Shabbos ends in LA. Quite late. I think last week I got up about 9:45. I'll aim to about the same this time. Renee, does this also apply, I wonder, to a frivolous matter, as to a false matter before a judge or jury? You just need to illuminate one lie from the witness and their credibility is shot as to all of their testimony. This question of credibility, right, as we saw when we were talking a little bit more specifically about witnesses, they have to come as a pair. And the judges, right, we talked about in Sanhedrin, there's two kinds of questioning that they do, where and when did this happen and did you see it? That's called the cross-examination, right? And if we don't get perfect agreement about that and the exact details, we dismiss the testimony, and then all the other details that go along with it. And there definitely is discretion for the judges, to develop a sense of who is being truthful and who is not. And Nina tells me there's also lots of discussion about firearms. Multiple members of the class carry and have learned self-defense. Please God, we should never need such skills. But as I mentioned at the top of the class, there is an advisory in effect right now, elevated threat levels to the Jewish community. This was released by Department of Homeland Security and the FBI. So we must be vigilant. If you see anything that looks odd, off, anomalous, report it. Maintain situational awareness. My holy sisters and brothers, you never want to be walking around in condition white, right? On Shabbos, that should never happen anyway. But at no time should you be walking down the street with your face in a phone or anything else. You got to be aware of your surroundings. You should at all times be in condition yellow, relaxed, but scanning. Condition orange means you've spotted something that is odd. And now you have a very much heightened awareness, heightened caution, and keep an eye on that thing. And if it really is suspicious, report it. And please God, we should never go into condition red, which means it's an emergency and you have to act, either run, hide, or fight. The worst of all is condition black. Condition black means you were in condition white, so you didn't know what was going on around you, and suddenly the emergency breaks upon you, and you're either in tunnel vision or it's just too late, you can't react. You want to avoid that at all costs by being vigilant. This is well outside the scope of the class, but it's what's going on in our world right now. That's what I've got, and with God's help, we'll be together again tomorrow night, safely hearing good news and coming out of the other end of what should be an uplifting, rejuvenating, relaxing, inspiring Shabbos. Good Shabbos.